for a differently worded crime at the federal level. But that is rarely done, And the more typical way, which is how the O.J. Simpson situation was handled, was for people to bring a civil suit under federal law, and of course, they won an enormous amount of damages. But if you're interested in lawyery things, and I am, Florida is not unique. There are a couple of other states like Florida which allow you a homestead exemption from bankruptcy on your home. And it doesn't matter how expensive the home is. So if you think you're going to be sued for some kind of malfeasance, the idea is to buy the most expensive house you can get, if maybe $20 or $30 million. And it makes sure it's your residence, as Mr. Simpson has ensured. And they can't get it. It's just too bad. You know, you may say that's kind of funny, and I agree with you, it is kind of funny, and probably unjust. Let me express that view. But it shows you a mindset, if you will, as to the relationship of the law and the courts. So you ask, is the law an enemy or a friend? Well, I can say the law can be used by your enemies to make very, very uncomfortable for you. Let's leave it at that. So it's sometimes friendly, sometimes an enemy, and one has to use his wits to decide how to live in that circumstance. All right, now, I've already told you what the ideal would be. Let's assume, however, that you're not going to reach that ideal, as I assume we will not, for the foreseeable future. What can the courts do on their own? And there are some precedents, even in common law countries. And indeed, in a country like Germany or possibly Greece, the courts might be able to manufacture a law working with these broad generalizations. What can we learn from the common law on this subject? And I'd like to discuss that for a little bit. It might be helpful. At common law, one of the oldest forms of action is the action for nuisance. Nuisance, at least in modern terms, is distinguished between public nuisance and private nuisance. The older form is private nuisance, and I'll discuss that first. An action for private nuisance is when one person who has an interest in the use and enjoyment of land sues another person who is using his land in a way that interferes with the first person's right to use and enjoy his own property. The way the world operated in simpler times, or at least so it seems, is there was communal agreement as to what was considered to be an unreasonable use. So the courts weren't inventing the thing. For example, it was accepted if your privy overflowed and it got into someone's house, that was not good. And various other things. Or if you dammed up a stream and it flooded your neighbor's property, that wasn't considered good. But it was dependent on the notion of communal interest. And to some extent, that's been carried over into modern nuisance law. If your house is in an area where there are factories, what is a reasonable use of the land will be different from what it would be if you lived in a residential area. To wit, if you had your house in an area where there were largely factories, you'd have to put up with a certain amount of discomfort. That's just it. In a dynamic society such as the United States, neighborhoods change, however. And the old notion that you can't move to a nuisance, in other words, go somewhere where the uses are different from your use, and then demand that other people stop doing what they're doing, was probably never the law. But in fact, though, over time, regardless of whether it was or wasn't the law, neighborhoods change. And so you get situations, a number of cases in the United States where people are engaged in pig farming. A case that I remember when I first started teaching, I teach torts as well, involved pig farms in the outskirts of Boston. And it was an area which was given to pig farming, but gradually it was suburbanized. And it got to a point where the people who had the houses didn't want the pig farms, didn't want the flies, didn't want the smells. They didn't want to go back to nature or live in a what have you sort of situation. And they brought in action, and they won. Now, in the United States, I don't know what the law is in England on this, but in the United States, in most jurisdictions, once you could prove that there was a private nuisance, and you were not satisfied with damages, in other words, not satisfied with someone paying you for an easement in order to continue engaging in that property, you were entitled to an injunction to stop it. With the rise of law and economics and larger scale enterprises, people started saying, well, gee, that's kind of wasteful. So a couple of courts tried to experiment with other devices, namely forcing in other words, giving the plaintiff a damage remedy but no injunction, which was the equivalent of forcing him to give an easement to people to pollute over his property. And the most extreme case was one in Arizona, which again involved a cattle farm, where they'd move one of these new communities, and the people didn't want to have the cattle around. And what the court did was give the plaintiffs a judgment, but only on condition that they paid the expenses of moving the cattle farm to somewhere else. And that sounded good. I mean, at least the law professors used to talk about that. But a lot of people pointing out, you know, in our country, you just can't take, only the government has the right to exercise eminent domain. And you can't, or you shouldn't, take property from one private owner to give it to another private owner. So those moves have sort of faded away, so to speak. So as I say, the law of private nuisance gives you some remedy against the environmental degradation. But again, it's limited in the remedies, limited to the people who can bring the action, and to some extent is governed by traditional uses rather than the sorts of issues which we're talking about, because many traditional issues, uses of land, many people consider to be unhealthy, unethical, or whatever you want to call it. A more promising avenue is the law of public nuisance. At common law, public nuisance was a common law crime. These crimes were court-created, but again built on custom. What was accepted as the customary or not customary use of land. The problem there is that for a long time the only one who could bring the action was the Crown. But in the 16th century, private actions were allowed for the public nuisances. But the plaintiff had to prove that he suffered special damages, namely damages that were different from those suffered by the public at large. For example, if someone was repairing his house and in the process of doing so blocked off the road, and you had an adjoining house so that you couldn't reach your house or had to do it by an extremely roundabout way, you suffered what is called special damages. And you could bring an action. But a member of the public who was forced to walk 3 miles out of his way in order to get home, he couldn't bring the action because his damages were damages the general public suffered. Now, this issue could have surfaced and may still surface in the litigation in the United States over the British, or the BP, with the oil spill. Because most of the damages there are a loss of profits, which is a pure economic loss, which is itself an issue in the United States and the United Kingdom, which I'm not going to get into. But the problem is, who has even suffered special kinds of these damages? The way the law is developed in the United States is that fishermen, commercial fishermen, have been held in several cases, including one in North Carolina, to have suffered special damages from pollution which has made it impossible for them to fish in their traditional fishing grounds. But people who had motels, where people would come to look at the sea or to bathe at the sea, were unable to sue. And that also arose in the Santa Barbara spill. I don't know if some of you are old enough to remember the big spill off of in Santa Barbara in California, off of the coast of Santa Barbara in California, again from offshore oil operations. Some of those issues may be raised again in the BP situation, but there is this big fund which BP has set up, which is going to be much more generous, at least as far as the scope of the people who can recover. And that may moot that particular question. So that's as far as I think you can get with this public nuisance theory. People have, however, tried to use not private actions for public nuisance, but the analog to Crown prosecutions or Crown proceedings, civil proceedings for remedies for public nuisance. In the United States, the appropriate plaintiff would be the Attorney General of the state in question. For local matters, it would be the local authorities, the mayor or whoever is the legal authority in the particular area. And there have been two cases which I think are worth noting. The first was in the early 1970s when an action was brought against General Motors and the other automobile manufacturers by the attorneys general of a number of states to force the automobile companies to retrofit cars which they had manufactured without pollution control devices. You know, that was a time when they were starting to bring in catalytic converters and forcing people to take the lead out of gasoline and other sorts of things. But all these regulations were prospective. They weren't retroactive. And so the action was brought against the automobile companies and their trade association to force them, I said action, strictly speaking, if you want to be a purist, it's a suit in equity and an action at law, but